Good morning. Are you Anthony Mendoza?
Yes, ma'am.
And Mr. Mendoza was previously in court and entered pleas of true to counts 1 through 13 in a motion to revoke probation. Currently on probation for driving while intoxicated, third or more. That was a 6-year sentence that was probated for 6 years. I've received an updated pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
Yes, Your Honor, we have.
Are there any additions or corrections to that report?
No, Your Honor.
Not from the state judge.
All right, Mr. Parker, you may proceed.
Well, a couple things I want to address. It's a situation I see quite a bit where he's ordered to have the SCRAM and interlock. It's costing him $600 a month, and he's having to go to work, but yet he's not supposed to drive, and so he's driving with an invalid license, and he's not able to work, and he can't afford to pay for the things he needs to do, such as the 12-step program, the GED program. All those things require money, and that's one of the big issues. But the things I'm concerned about is that it says that he went to the safety relapse program. I'm not sure exactly what happened, but he says he never went to the safety relapse program. I don't know if he was ordered to go and he didn't go, but I think he was in custody at the time, and I'm not sure how that happened. But he also says he's never tested positive for cocaine, which is alleged in here. It addresses an issue that he apparently had with one of the directors of the facility where he became combative. And this also, in turn, is tied to a SCRAM device. He ended up developing a big sore on his ankle, so he would put his sock behind the SCRAM device. And in this incident, he was frustrated, and he wanted to take his boot off to show the director the problem that he had. And that's when they were saying that he was being disruptive. He has no other felonies, Judge, and he wants the opportunity to go back he wants to complete his probation. He wants to do the safety relapse. I'd like to hear what they say of what happened with that, but I'm sure there's an explanation. And I think you'd also like to address the court, Judge.
Well, let me first make sure I've got the timeline, because it appears that I see that safety he completed and then was placed on zero tolerance in the high-medium caseload. And after that, there was an issue where he was testing positive, again, for alcohol and cocaine, which I understand he denies the cocaine, but that's what this alleges. And in October of 2022, I'm assuming through an administrative hearing, was granted relapse safety.
Yes, ma'am. There was a motion to revoke that was filed and came before the court, and he was ordered to go to relapse safety, and he absconded, and he never went to relapse.
So he wasn't in custody?
No.
Okay. And then, so we didn't see him again until August 11th of 2023, when he was arrested in Houston. So here's the thing, whether you probably didn't get any paperwork. Come up here to the front, in the middle here. From at least October of 2022 until August 11th of 2023, you wouldn't have known about anything because you quit going to probation. You were an absconder. And the only reason we found you is because you were arrested in Houston for aggravated assault with a deadly weapon. And then in May, we get you back here, and you were sanctioned to 180 days in jail. So this is the third time, it looks like to me, that you would have been given an opportunity to remain on probation. I gave you upfront time, continue you on probation. Courtesy supervision was sent to Harris County, and then we have the SCRAM device issues still, alcohol violations, interlock violations, aggressive behavior, ongoing alcohol use. So if you didn't do the relapse safety, it's not anyone's fault other than your own, because if you didn't know about it, it's because you weren't going to probation. Mr. Nichols?
Judge, I think it's pretty clear. He was put on zero tolerance a couple of years ago, and here we are on the second time.
Third.
Multiple times.
Yeah.
And I don't know what else we could do. So obviously I agree with the probation department's recommendation for revocation. I think he's had more than enough chances, Judge. In fact, there's just one thing I want to make the court aware of. If I can call Ms. Martinez, real
Yeah,
quick.
sure. Ms. Martinez, would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Go ahead.
Ms. Martinez, you were supervising, well, Mr. Mendoza was on Harris County supervision, correct?
Yes, sir.
And you were back in October when he started having these violations and the warrant was issued. Did you advise him to turn himself in?
Yes.
And what was his response to you?
He had responded with an email that said, "Ha."
That was his only reply to you? Did I ask you to print me out a copy of that?
Yes.
Showing you what I marked as Exhibit 1 for purposes of this hearing. Is this a copy of the email with his reply to you?
Yes.
I'll tender to the defense attorney, Your Honor. Tender to the court for purposes of this hearing, I'll offer State's Exhibit 1.
It's admitted.
And is that pretty consistent with his level of cooperation and attempts to prevent probation while he's been supervised?
Yes, sir.
No other questions, Your Honor.
All right, any questions?
Just a couple. I want to clarify on the relapse program. You said he was y'all came to court on motion to revoke. Is that my understanding?
Yes.
And so the safety relapse was ordered by Judge West.
Yes.
And when he was here, the defendant was here. Mr. Mendoza was here at that time.
Yes, sir.
Well, wouldn't he have been taken into custody?
Let me make sure, because I wasn't supervising.
Okay.
It looks like the hearing was completed over the phone. Okay, wait, he wasn't on here, it was over the phone with the supervisor at that time. Due to him residing in Houston, he reported he had a lack of transportation to report back to the hearing at that time because he had tested positive for alcohol and cocaine. The supervisor had recommended complete relapse safety and issue a warrant for his arrest. So he wasn't made aware at that time that he was going to have a warrant and we were requesting relapse safety.
I have no further questions of her, Judge.
All right, anything
I have no
else?
other questions for Ms. Martinez,
Your Honor.
Your Honor.
Thank you, Ms. Martinez.
I think he wanted to address the court, but we never did because we
Sure.
talked with her.
Go ahead.
Would you like to tell the court? Do you want to tell the court?
Y'all saying I went to safety twice, I never went.
Nobody's saying you went to Safe P twice. We're saying you went to
You're saying
Safe P.
I'm
Hold on,
absconded?
don't, listen. I'm gonna let you talk, but don't talk over me. We're saying that you went to Safe P and then that you were ordered to go to the Safe P relapse, but you never came and turned yourself in after that phone call where you were told that there was to be a warrant for your arrest. So no, you never went to Safe P relapse. Go ahead.
She said I was supposed to turn myself in. That was after I did the 9 months where felony assault got dropped to a misdemeanor terrorist threat.
Mm-hmm.
So when I was here, y'all let me out. And then I was trying to work and they kept saying that I was messing with the SCRAM device.
Okay.
So I was actually at work and she sent me a message to my phone. And I was trying to work and trying to pay, for the devices and stuff, since they were violating me for operating my truck without court permission.
Mm-hmm.
So that's when I just didn't turn myself in.
Right. So did you respond? Is that email, that was
Yes,
what,
ma'am.
that's what you thought about all that?
Yes, ma'am, I did actually say that.
You thought that was funny?
It's cause I was agitated and I was taking lunch at work, and I was trying to, do things, trying to make money to take the classes, but with being on the SCRAM device.
Well, you had money to buy
nothing.
alcohol. You hadn't, because you kept drinking, because you kept messing, Mr. Mendoza, you have been given so many opportunities on this probation, and I understand that those things are expensive. However, if you had at any time stopped testing positive and having blood alcohol readings that were positive on those things, then you could have eventually gotten off of those. I don't keep people on those for very long, but the reason we had to keep doing it for you is because you kept drinking. You kept messing up. And so you don't get to say, I kept messing up. Seriously, you got the initial probation in 2021. You got you got Safe P. You got some upfront time because of the Harris County issue, didn't revoke you, haven't revoked you, 3 times haven't revoked you. And here we are with all of these violations.
Through the TDCJ program, I was doing what I needed. The only time I had issues when I had the foot problem that I got from the halfway house. That's the only reason they said I absconded from the TDCJ program.
Okay.
I've actually done well through the program, through with the supervised division. The only time I messed up is when they stopped supervising me and made me go do these things by myself.
Well, I mean, how old are you? How old are you?
I'm 43.
43 years old.
And I have no felonies on my record except for this.
That doesn't mean anything. You have this felony and you have 6 years hanging over your head. And you've been given all the tools. You went to safety, you got to aftercare. At some point, you have to take those tools and do for yourself and not come in and say, well, they made me do it for myself, so it's somebody else's fault that I kept drinking. We gave you the tools.
If I can go
We're done.
through
At this,
another
we're done.
safety again,
No, we're done.
let me kiss
At
my
the-
ass.
Mr. Mendoza, turn around. You can say whatever you want, but you're gonna face me and you're gonna get your sentence. And if at this time I could give you more, I would, I promise you, but I can't. So I'm going to find that you entered your pleas of true to counts 1 through 13 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, and at this time revoke your probation. Sentence you to 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you a certification of your right to appeal. This was not an agreement, so you do have some rights to appeal. Y'all need to sign that before you leave right now. You need to sign that you're getting a copy of it, and then we'll give you your copy, and then when you're done with that, you can go back with the bailiff. To injury to a child, a first-degree felony. I've received the pre-sentence report as well as I've visited with the attorneys, and for the record, we have also Ms. Randy King here, who is the assistant district attorney that handled the termination and CPS kind of portion of this case with regard to the children. I've received, has everyone had an opportunity to review the pre-sentence report?
Yes, Your Honor.
Are there any additions or corrections to that report?
No additions or corrections.
Ms. Smolfino?
Judge, I would just ask the court, take judicial knowledge of the conversation we have had with the court and the understanding that this has been discussed at length upstairs. Ms. King has also provided me a tremendous amount of guidance, which I thank her and appreciate everything she's done with her wealth of knowledge and experience in guiding me through this case. I know the facts themselves are extremely egregious. It's difficult for all of us to look at. I would recommend Ms. Schultz is getting this opportunity because she has availed herself of certain things and tried to make progress. The children, her rights have been terminated, which she voluntarily gave them up, and they have been relocated out of state to a stable environment to where they will not have to testify against their mother, which was something that we took into a great deal of consideration. I would ask the court consider special needs safety in lieu of ISF cognitive. I think it is a more lengthy and a more appropriate term in custody as either an upfront type of sanction, but more so to give her the tools to be successful on this probation, because as the court is aware, and I'm sure Mr. Samuel has advised Ms. Schultz, and I do not mean this statement to seem punitive, but if Ms. Schultz is back before you on a violation of this probation because of this opportunity she's been given, the amount of time that the state will be asking for will be overwhelming.
Thank you, Ms. Smolfino. Anything, Mr. Samuel?
Yes, Your Honor. I understand the position of the state. However, I have to look at things from the position of the individual. The pre-sentence investigation report shows that she has no prior criminal history. It shows that she has no drug problem. There is a question about the alcohol. However, we believe that that can be done without the need of the inpatient treatment of the ISF. We believe that she's finally working. That is one of the most important things that she has to deal with in what she's gone through. She's experienced the trauma of relationships. And I think all of that is stated in the pre-sentence investigation report. But what you do not hear is the experience with the other partners of the children. She has carried this burden. She has tried to do the best that she could at the time. She's educated, she has a degree, but she has not been able to find employment. She's finally working, and we just ask that this be held in advance for at least 90 days. That will show if there's an alcohol problem. That will show if there are other problems that she's experienced. She has been to a mental health specialist for counseling, and she will get with them again. And we believe that if that is a part of the order for mental health compliance and conditions, she can do that. But let her prove to the court that this is not just her as it is today. This is a result of everything that she's experienced in her life at this point. I just pray that the court will have mercy on her and give her that opportunity.
Well, Ms. Schultz, you're getting mercy today. You're getting mercy from these ladies as well as myself, if I go along with this agreement. Mr. Samuel has worked very hard and is very passionate about helping you, and I appreciate that. My position on this is based on a couple of things. One, the horrendous nature of this offense and what you put all of your children through, all 10 of them, is beyond anything that I have seen in 30 years of practicing law. 30. And so you're not walking out of here today. My initial thought was some upfront time, but if I'm going to stick you in jail, then I might as well put you somewhere where you're getting some help that you need, so that when you are released, you hopefully will be able to be a productive part of our society. But whatever trauma you've been through is incomparable to the trauma that you've put your children through. So at this time, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. I'm going to follow this agreement only because of the work that Ms. Malfino and Ms. King and your attorney have done, and the agreements that they've reached, and I understand why. Part of that is so that your children don't have to be re-traumatized and come back here for a trial and testify against you. I don't want to re-traumatize your children, and that's the only reason I'm really going along with this. So I will defer all proceedings, place you on probation for 10 years. You will be ordered to pay the $1,000 fine and follow all of the rules and conditions of probation. One of those is going to be that you enter and successfully complete the special needs safety program. You will be on the mental health caseload when you're released, and you'll have aftercare through Spindletop. That is now part of your probation. So if you don't follow through with any mental health services that are recommended through Spindletop or probation, that's going to be a violation of your probation. You will also be ordered to remain in Jefferson County, Texas. You cannot leave Jefferson County without permission. You cannot go anywhere near or see your children. You've terminated that relationship. I know they're with family. And so there's no Christmases where you show up or they bring the children down or anything like that. That's done, that's over. If you want to leave Jefferson County, it has to be with my permission, and I will have to know where you're going and to what extent and things like that. If you do everything you're supposed to do on this probation, I cannot stress enough what kind of opportunity this is that you're being given. If you, however, violate any condition of probation, if you're back here in court, obviously this isn't a case that I will ever forget. And Ms. Malfino will also, like she said, if you violate probation and come back in here, depending on the case, what you violated and how you violated, you could go to prison for anywhere between 5 years and up to the rest of your life in prison. Do you understand? I'm handing you the trial court certification that shows this was an agreement and I followed it. So you've waived your right to appeal So you can, go, that's for her. You can go back with the bailiff. Thank you, Ms. King. Thank you, Ms. Malfino, Mr. Singh. Did I already do any of the sentencing, or did I just let you guys kind of know that I was leaning towards probation and that we needed to have?
I know it's indicated on January 26th of this year, we appear, we discussed the PSI. There was a disagreement as to the restitution. The court says that it was inclined to place the defendant on a concurrent probation, given the length of time between office date
Right.
and the indictment. Then fast forward to February the 9th of 26, the case was simply just reset for restitution hearing. So it looks like you didn't do
And
anything.
haven't actually sentenced yet.
I don't believe you did, Judge.
Okay, and have you, so, all right, ma'am, you're Janisha Leonard. And Ms. Leonard's here in 3 cases. One is cause number 25 DCCR 0297. That is the new theft of property case, a state jail felony. She entered plea of guilty to. And then we have 2 MTRPs, one in cause number 19-33340, theft of property, and 20-36095, a theft of service. And in each of those cases, is she on a deferred in both of those? Or is this true? I'm trying to, sorry, I should have. Is it a deferred probation?
Let's see, Judge.
No, they're straight probation, Judge.
Okay.
Yes.
So they were deferred and then we were here. And then revoked that deferred and reassessed and did the 2/5 at some point. Is that correct?
The last information I have in my files is she was on a straight post-conviction probation. I don't know if she initially was on deferred or not.
Yeah.
I don't
okay.
know.
All right. Yeah. Okay. So, the biggest issue that one of the bigger issues that I had when we were here for sentencing, based just on paper and the appearance of this, I don't disagree with Mr. Coleman's assessment of the case, with the criminal history of Miss Leonard with these types of offenses and, which the criminal history is these 3 cases. There aren't any other cases. And the new offense date was August of 23. And kind of just unknown, it sounds like, why that case was delayed in prosecution. Doesn't look like anybody knows. And so the time frame between that and now, and the lack of any other cases while Miss Leonard has been out and on probation during that time and doing well, it looks like otherwise on probation, is what leads me to potentially move forward with continuing the probation potentially on the others and giving her a probation on this one. So there was no agreement on any of these, but it looks like there was an issue with regard to the amount of restitution. So let's go forward with that. Have you guys come to any type of agreement on the restitution?
We are very far
We're
apart.
very far apart, Judge, and I guess one of the issues that we have is I believe Mr. Coleman's got some exhibits that are gonna go back to 2022. I would object to looking at anything outside the range in the indictment. The indictment goes from August 23, and we'll get to the exact dates,
Let me get it pulled up as well.
August 24th, 23 to September 4th, 23.
Okay,
I would ask that we remain in that range.
I would think legally that would be probably what I would need to do.
Judge, it's a continuing course of conduct. The theft is, I'll be honest, Mr. Ross just brought that to my attention this morning. I haven't had a chance to research it, but he certainly has had all of the restitution information showing that it's going back to 2022 with that discussion. So it's not an unfair surprise for him to know that we're looking for restitution going back.
Well, but I think the allegations, and obviously I understand the honor about as well as any of you guys, but those are some pretty specific. I mean, that's a very short time frame that is alleged in the indictment. Talking what, 4 days,
Well,
5 days?
yes,
Well, yeah,
from August 24th, 2023 to September 4th.
I'm sorry, I'm looking at an old indictment. I'm sorry, hold on. I was looking at another
About
case.
10 days maybe.
Hold on. So in the new calls number. So yeah, this one is August 24th of 2023 through September 4th of 2023. So less than a couple of weeks, a couple of weeks or so is the allegation. And I don't want to have to keep coming back here. But I think to go back, if it was a few weeks off or a month or two off, but if we're talking years of requesting that, then I think that's something that indictment needs to allege. And so we can go forward with that time frame today. I think legally that's where we need to be. She's already pled to it, so I think it's kind of late to amend the indictment. So with regard to the time frame of August 24th through September 4th of 2023, what is the amount between that time frame? Do you guys have that? Or need some time to look at it again to make? And I mean, and the unfortunate, I want to make sure you guys know how I am. If someone has had something stolen, I want them made whole as much as possible. I just don't think we can go back
Sure, Judge.
that far legally. So I want to make sure that the victim understands that as well, that we've got kind of a limited time frame here that we need to move forward on. If I'm going to order restitution and probation. Y'all need a minute to do some math?
Just a
on-
quick minute, just.
Yeah, y'all,
some
go ahead,
dates.
y'all have a seat based on, I guess, that. Um, see if there's something you guys agree to as far as that time.
Just based on an honor about date, and they understand that the court's willing to kind of go back a number of weeks. I've got receipts to go back as far as, I believe, August the 9th of 2023. I don't know that that would necessarily be, I think that would be enveloped in the honor about. I mean,
I wouldn't disagree with that.
so
So August 9th, 2023. And then what was the last?
the last.
Is
one
that the
was-
September 4th
the-
date?
The last one is, I don't want to misquote. Let's see here. September the 4th is the last day.
All right, so you guys figure out what between August 9th and September 4th of 2023 number is and see if there's an agreement on that number.
And that brings this case to a close. Anthony Mendoza came into court asking for another chance, but after repeated probation violations, missed requirements, alcohol-related issues, and multiple opportunities from the court, the judge ultimately decided that probation had failed. The 6-year sentence was revoked and Mendoza was sentenced to the Texas Department of Corrections, with credit for eligible time already served. But what do you think? Did the judge make the right call, or should Mendoza have been given one final opportunity to complete probation? Let us know your thoughts in the comments, and if you want more real courtroom breakdowns, make sure to like, subscribe, and turn on notifications for the next case.